this is going to be a fun one. The DOJ just responded directly to some pretty intense criticism that we just have. We're going to talk about that in a second this week of them around 2A activism and 2A support. I've got some lefties that are going to show you their asses, and I'm just going to basically be quite honest with you. We're going to rub their nose on the fact that they were wrong, like you and I talked about. And then we're going to kind of break down on what the Assistant Attorney General actually said in the video that she just made addressed directly to gun owners. Guys, this is going to be one you're going to want to send out because I think there's some things in here that are pretty essential to say. Let me know what you think in the comments field below. Everything is linked. Of course, make sure you hit the like button, subscribe to the channel, turn the notification bell on because we are in this for the long haul and handing the generation behind us a better experience than we had. All right, listen. You can follow me at Braden if you want. I don't want to bury the lead. I'm going to show you exactly what we're talking about. This right here is the Assistant Attorney General of the United States. If you guys are not familiar and you're one of the newer people that joined in, there's 100,000 of you guys who joined the subscription to the channel itself and the viewership in the last 30 days. So we've got really hardened 2A experts and 2A veterans, and then I've got the newbies, okay? When I'm talking to the newbies, you have to understand what we're dealing with here, okay? This is all about her addressing criticism from a case called Reese versus ATF, which was an 18, 19, and 20-year-old ban of gun ownership, okay? Think about this to the newbies. Think about this if you couldn't vote 18, 19, and 20. Say you don't have a gun, for example, and the government, through a bureaucracy, decided, like the FCC or something, decided you couldn't vote because you were 18, 19, and 20. No other reasons, just because you were 18, 19, and 20. It's an infringement upon a civil right. It's an infringement upon the Bill of Rights. That's the whole point. That's why I want to try to build these bridges together, because once I show you what's going on in the gun world and what's going on in the broad politic, you're going to make the connection, and it's crazy because the exact same tactics are being used against us in all of the niche spaces, okay? Now, this woman and her boss, Pam Bondi, received a hell of a lot of criticism this week. In my opinion, some criticism was due. And my other side of my opinion, there is a difference between going from 0 to 10 million and offering feedback. That's my own personal opinion. I think there was a little much going out, specifically with some of the content that was produced across all boards, not calling anybody out. But what I want to draw your attention to, she didn't have to do what I'm about to show you. And that's a very important point. Because in the face of getting some pretty intense criticism, pretty intense, she could have said, read between the lines, F right off, and we're never doing anything for you again. But instead, she offered a video not only of reaching out, but also of explanation. And that's, before I get into this video, I really want to drive home that point. If you've got somebody in the federal government who is wanting to be a pro-2A advocate, and you have somebody in the federal government who has actively taken part in defense of the 2A in a lot of ways that other people have not done prior, if they are reaching out after they get the intense amount of criticism that was just dealt very directly, that speaks to their intent. That's not the actions of an enemy or a foe. That's the actions of someone who's trying to help you. Now, you can agree or not agree. You can let me know what you think in the comments field below. But I think it's kind of hard to refute the fact that she made this video and the tone and the tenor in that video. In my opinion, she deserves credit for reaching out. Now, how that response received and how the response is given back, I personally think that there's some credit that should be due. But you know what? I can only control what happens on this channel. So let me know what you think. Let's get it. We're going to walk through the whole thing in 2-minute segments.
Hi, I'm Harmeet Dhillon, the Assistant Attorney General for Civil Rights at the United States Department of Justice, Civil Rights Division. And I wanted to share with all of you an update about our Second Amendment work under Pam Bondi's leadership. The Attorney General works closely with me and others here in the DOJ, as well as folks in the White House, to help expand our Second Amendment rights throughout the United States. And it's personally something that I'm very passionate about, and have been a longtime gun owner and advocate in court for Second Amendment rights. And so let's get right to it. There was a case this last week that was in the news. It was a case that's known by the name of Reese. In this case, a couple of our national gun groups challenged the under 21 sale of weapons by FFLs, and they won. They won an injunction from the district court. And so we at the DOJ decided not to appeal that. And we agreed to work with the plaintiffs to get as broad as possible an injunction consistent with the recent United States Supreme Court decision, Trump versus Casa, in which the court limited the use of these so-called nationwide injunctions. So without being nationwide, we did agree that the ruling would take effect throughout the Fifth Circuit Court of Appeals, in which this district court was, but would also apply to plaintiffs in these groups. And so the district court issued an order last Thursday saying that the gun groups would have to disclose the names of their members in order to have them covered by this injunction. So we didn't agree with that, and of course the plaintiffs didn't like that. And so we agreed and jointly stipulated on Friday last week to go back into court and ask the judge to withdraw that and amend the judge's order. And today the judge did that. And so everyone is happy, and the gun groups are not required to disclose their membership, and a broad as possible injunction.
All right, while that renders, I'll just kind of do some commentary on that piece. Two things that I want to talk to you about in the Reese case and the idea of handing over and distributing the ownership or the membership list of these groups. I told you on this video, you can go back, I've done it in 2 videos now. I told you it was not going to happen because it was so untenable that no court was going to accept it. No DOJ was going to accept it, Republican or Democrat, it didn't matter. It was so inane that it wasn't going to stand. And here we are today, it's not standing, right? But the reaction was immediately launch all missiles instead of, okay, we're going to fix that. That's the thing that I'm really trying to address here. I will absolutely go full on Top Gun and Maverick when it's ready to switch to guns in the proverbial political fight. Let's switch to guns, switch to missiles, let's freaking go. But there's also times where I will go, excuse me, what now? Let's have some conversations offline. And for her, again, to come out with this tone of explanation and reaching out and reaffirmation, that's a thing in the positive. That is something that allies do. That is not something that enemies do. So the entire concern, which caused a lot of the final straw this past week, is now gone. It is now moot. It does not exist. Okay? Now, let's keep on going because it's about to get more interesting as she goes into some other things. Okay? Listen to this. Again, these are not the actions of an enemy. And I just want to draw the attention to that. You can disagree or agree, and let me know what you think in the comments below. You guys know I'm not a fan of all Bonnie's actions, so don't try to pin me in that corner. But listen to this.
Membership and a broad as possible injunction. The cooperation of the DOJ is in place. So really excited about that. Some of the affirmative things that we're doing at the DOJ on gun issues include, I went personally to the Seventh Circuit last month to argue a challenge on the amicus side for the United States to Illinois' ban on a number of very popular weapons, including the AR-15, which, as you know, is the most popular rifle in the United States, and which Justice Thomas has written favorably about as presumptively being something that, being a popular weapon used for legitimate purposes by law-abiding citizens, should be considered constitutional. So that's the direction of the court, and that's the direction that we believe compels Illinois' law to be struck down. Then there are other states that have laws like this, and we're filing these amicus briefs around the country. Another example of that is a case called Wolford versus Lopez in Hawaii. Hawaii has a broad public carry ban that would appear to be inconsistent with several Supreme Court precedents. So we have gone into court on an amicus basis there in the Ninth Circuit to challenge that law as well. Really excited about an affirmative case that I brought together with my team here in the Civil Rights Division just 2 weeks ago, where we sued the LA County Sheriff for taking as much as 3 years to process concealed carry permits. Now, under United States Supreme Court case Bruin, it is basically a shall issue regime for law-abiding citizens, and taking 3 years is not really shall issue, is it? And so we are hoping to get that precedent established if we have to go all the way in that case. And that is the case in some other states and municipalities as well. So that's going to be a very important case to watch that could expand people's liberty throughout the United States. We have a Attorneys General's Second Amendment Task Force, which is looking at different things, including beginning a registration process for former nonviolent convicts to be able to resume enjoying their Second Amendment rights. I think this is a really important and very liberty-oriented position that the DOJ is pushing. We're also looking at including suppressors in the scope of the Second Amendment and how to harmonize the case law and regulations with that.
All right, that's an important piece. And again, guys, we're going to get into the weeds on this, especially if you're one of the newbies, but you have to understand what's happening right now. These are unprecedented things that happen in the two-way space. Unprecedented. Now, for all my existing two-way veterans out there, there's also things that Bondi has not done well. I have been the first one to tell you that. But there is a feedback option. Like, this is something that happens in our political discourse. That almost got weird. Political discourse right now. It's either you say nothing or you nuke someone from orbit. There is a middle option. Like we do have the feedback pushback model versus you're dead to me. The suppressors going in as Second Amendment arms is another point of contention that happened in the DOJ with Bondi and the AAG and all of these people. They had elements inside the U.S. attorneys who were doing these things, and then they corrected them. The district court, in this case with Reese and 18, 19, and 20-year-olds, issue was dealt with and corrected. You are seeing a lot of mistakes, but you're also seeing a lot of corrections. To be completely fair on both sides of that scale, okay? I don't think that you put it into a position where you are completely writing off anything and every advantage you possibly could have because you're skipping past that feedback stage. That's my own personal opinion on this. But anyway, let's keep going. She's going to address the biggest issue that a lot of people have right now about the NFA as well at the end of this. All right, let's get it.
We're working with ATF on ATF's review from top to bottom of firearm regulations. And, people have a lot of issues with ATF and how it's administered some of these. There's been some zero tolerance policies by prior administrations. And I think we're going to do a lot better in this administration if folks will give us a chance to, really get rid of some of this old stuff that shouldn't be on the books and harmonize our laws with the constantly evolving precedents. The final point I'm going to make today is there's a case also in the news called Rush versus United States. And in that case, the plaintiffs are appealing or seeking to get certiorari to the United States Supreme Court on National Firearms Act requirements for short-barreled rifles. There's some registration and some taxation requirements in that law. Unfortunately, Supreme Court precedent to date and all of the courts of appeals have not been willing to go so far as to say that short-barreled rifles, whether they're sawn off or otherwise, are presumptively constitutional. Now, that may be something that could change in the future. It's probably something for people to discuss with Congress, but so far the Supreme Court cases on this issue have held that there are some different characteristics of the short-barreled rifles versus the others that are more commonly used, and they may be more dangerous and so forth. So whether you agree with that or not, it's not really for the DOJ to make that call, but the DOJ's call in this case was our Solicitor General, who's down the hall from me, John Sauer, has opposed cert in that case, holding that there isn't a sufficient ripeness here, there's no circuit split, and the law simply does not support the plaintiff's position in this case. And so these are complicated issues, and I know people are very, very passionate about them. I am too. And so I would ask that folks who are very passionate, interested in these Second Amendment issues, talk to us, talk to Congress, talk to the White House, give us some grace, give us some time to deal with these issues while right now we're in a shutdown and we're still doing so much stuff that is important in matters of public safety. But please trust and believe that this is the most Second Amendment friendly Department of Justice in history. Yes, that's a low bar, yet we managed to rise way above it. I'm proud to be part of that and look forward to hearing from and engaging in dialogue with all of our allies throughout who believe passionately that the Second Amendment is a first-class right in this country.
All right. Here's the thing, guys. I'm going to wrap this real quick. Those are not the words, and that is not the video of an opposition or an enemy or a betrayer or a saboteur. Those are the words of someone who seems to be looking to find ways to do what she's trying to do. Now, is she going to be perfect? No. Is AG Bondi perfect? No. I would like to reinforce, this is not a pro-Bondi, anti-Bondi video. This is objectively about this individual video that I just showed you. That is the action of someone who is reaching out. That is not the actions of someone who is looking to give you the middle finger. I'm just saying, feedback might be a better option than just setting the world on fire. I don't know. Maybe that's just me. Let me know what you guys think in the comments below. I'll see you in the next one. I'm Braden. Later.